A phone call this August caught homeowner Trita Rogers by surprise. The caller asking when she was moving out.
And I said, "What do you mean?" He says, "Well, I bought your house in an upset bid."
This was news to Rogers. She had already paid off her Pitt County home of 12 years.
So I kind of thought it was a joke.
But she soon found out this was no trick.
Imagine living in your home for 12 years, owning it outright with no mortgage, and then one day a stranger calls asking when you're moving out because he just bought your house that you thought you owned free and clear, and you had no idea it was even for sale. Trita Rogers of Pitt County answered that call in August and said, quote, "What do you mean?" And the caller calmly replied, "Well, I bought your house in an upset bid." And in that moment, her entire world collapsed because she had no clue her home had been foreclosed on and sold nearly a year earlier. Over a debt she says she never even knew existed. If you want to see how easily a home can be stolen from under someone's feet, hit that subscribe button right now, because this story is a chilling reminder that scammers and broken systems don't just target the careless. They target everyday people who trust that the law will protect them. And sometimes the betrayal comes not from a stranger, but from the very institutions that are supposed to serve the community. For more than a decade, Rogers lived in her Pitt County home without any disruption, having purchased it roughly 12 years earlier and paid it off in full with no mortgage company involved, no monthly loan statements, and no lender with any financial claim against the property. So as far as she understood, the house belonged to her outright, free of debt and free of dispute. She lived there continuously, maintained the property, paid her property taxes, and carried on the ordinary responsibilities of a long-term homeowner with a daily life that reflected complete stability. At some point after she bought the home, the neighborhood became subject to a homeowners association, and Rogers maintains that she did not understand that her property was part of an HOA.
Why didn't you pay the $1,400? What's your response to that?
That's all I hear. And I say, I would have if I known.
No one ever came to your door. No one ever called you. No one ever sent you an email saying you owed this much.
No.
Or that membership required the payment of regular dues. And she says she was unaware that the association had the authority to impose assessments or enforce them through legal means. In her view, there was no clear moment when she knowingly joined an HOA or acknowledged its rules and obligations, and because of that, Rogers did not believe she owed any HOA fees and did not intentionally skip payments because she says she simply did not know the dues existed. The amount that eventually became central to the case totaled about $1,400 in unpaid HOA assessments. And Rogers has said that if she had known about the debt, she would have paid it because the sum itself was not something she considered impossible to resolve. When asked why she didn't pay the $1,400, Rogers said, "That's all I hear, and I say I would have if I had known." And she explained that no one ever came to her door, no one ever called her, and no one ever sent her an email saying she owed this much. Court records show that the Homeowners Association had previously placed liens on Rogers' property in 2013 and again in 2017 related to unpaid HOA dues. And Rogers says she did not receive or recognize notice of those liens at the time they were filed and was not aware that legal claims had been attached to her home. Those earlier liens did not immediately lead to foreclosure, and Rogers continued living in the house as usual without interruption.
HOA never served her lawsuit papers. They just didn't do it. That is fatal. The thought that someone could just casually move forward and take someone's home over a $1,400 debt without turning over heaven and earth to make sure that they knew just seems wrong.
And life at the home remained unchanged, reinforcing her belief that there were no unresolved legal issues affecting ownership. Years later, the Homeowners Association moved beyond liens and initiated foreclosure proceedings. And according to court documents, notices related to the foreclosure were mailed to Rogers, and she acknowledges that letters arrived at her address but says she believed they were legal advertisements, and based on that belief, she did not open them or read their contents. Rogers states that she was never personally served with the foreclosure lawsuit papers, and says no one delivered documents directly to her, posted papers on her door, or otherwise ensured she received notice in a way that clearly communicated legal action was underway. Her attorney later stated, quote, "The HOA never served her lawsuit papers. They just didn't do it. That is fatal. The thought that someone could just casually move forward and take someone's home over a $1,400 debt without turning over heaven and earth to make sure that they knew just seems wrong." And those words capture the moral outrage at the heart of this case. Rogers did not participate in the foreclosure process, did not appear in court, file a response, or challenge the debt because from her perspective, nothing was happening that required her involvement since she did not know a case was proceeding against her property. The foreclosure process continued without her participation as the Homeowners Association moved through the legal steps required under state law, and Rogers remained living in the home throughout this period unaware that ownership was being transferred. Approximately 11 months before she learned anything was wrong, the foreclosure was completed, and the home was sold through an upset bid process.
So I think the problem is there really is no such thing as HOA foreclosure defense in North Carolina. The law is tilted heavily in favor of homeowners associations.
At the time, the property was valued at approximately $413,000, but the final sale price was $221,000, significantly less than the estimated value of the home, and Rogers was not present at the sale because she says she did not know it was happening. After the sale, there were no immediate changes at the property that signaled a transfer of ownership, and she continued living there believing she was still the lawful owner, until her first indication that something was wrong came unexpectedly when she received that phone call from a man who asked when she planned to move out. Confused by the question, Rogers asked what he meant, and the caller told her that he had purchased the property through the upset bid process. And the call caught Rogers completely off guard because until that moment she believed she owned the house outright. As she began to look into what the caller was saying, she realized that the situation was real. And through further inquiry, Rogers learned that the foreclosure had been completed and that her house had been sold nearly a year earlier, and this was the first time she understood that ownership had already transferred. After discovering what had happened, Rogers sought legal assistance, and an attorney reviewed her case and focused on whether the foreclosure process had complied with legal requirements, particularly those related to notice and service of process. According to her attorney, Rogers was never properly served with the foreclosure lawsuit, which he argues is a critical procedural failure, and the legal challenge centers on whether Rogers was given adequate notice and an opportunity to respond before the foreclosure moved forward. The management company associated with the Homeowners Association declined to comment publicly, citing the pending lawsuit. And court records show that the same association filed liens against 5 other homes in the previous year, all for amounts under $1,200, demonstrating that Rogers' case was not isolated. Rogers' situation illustrates how homeowners association enforcement mechanisms operate separately from traditional mortgage systems, and under existing law, HOAs can place liens on properties and pursue foreclosure for unpaid dues even when the amounts involved are relatively small compared to the property's value. Rogers remains in the home while the legal process continues, and she has a scheduled court date where she will attempt to have the foreclosure set aside and ownership restored. Her attorney made it clear that, quote, "There really is no such thing as HOA foreclosure defense in North Carolina. The law is tilted heavily in favor of homeowner associations." And he argued that the process should be much harder with strict notice requirements and strict proof of notice. Stay vigilant, read everything, ask questions, and never assume the system will protect you automatically, because sometimes the greatest threat to your home isn't a scammer on the phone. It's a faceless process that moves forward in silence while you're living your life unaware. Stay safe, stay informed, and we'll see you in the next investigation.
It seems to make it harder for an HOA to foreclose. I mean, they're just simply people who don't understand that it's too casual a process. I think the process should be a lot harder. There should be strict notice requirements and strict proof of notice.
Rogers has a court date next month where she's going to try to win back her home. Now, some tips for you. Before you buy into a community, know if they have an HOA. Read those bylaws. And once you're in, vote for the board, participate, go to those meetings so you stay informed.